Hello, my name is Dr. Nick Skrekis and I'm the Ethan Hathaway Expert Trainer for International Business Law. I present the public seminar of International Business Law for Finance Professionals, which is just a fascinating and a very deep effort, which is quite comprehensive and also includes several workshop sessions, so it's hands-on. Today I'd like to touch upon 10 common mistakes business people make when confronted with international law issues. And I think you should listen carefully because it may save you some time and money. The first mistake I identify is that some people think that any international law issue can be solved later on. I mean, there's a tendency amongst entrepreneurs to think, once I get my funding, once my business plan is up and running, then I've got time to hire legal experts and do it that way. This is short-sighted logic. Many problems can't be just patched up later. Some consideration of potential problems can save you a lot of money, grief, trouble, and time. I mean, let's look at an example. For instance, a situation of conflict of laws and jurisdiction should be proactively decided early on because they can't be adequately managed when they explode. For example, in an equal joint venture of two companies based in China, let's say they buy a factory on a property halfway around the world in Zimbabwe, and after the first year they fall out on its usage after purchase. The issue will be which country's laws and courts will decide the hot dispute. Will the law and the courts that decide the case be halfway around the world in Zimbabwe? Well, if there's nothing in the contract, yes, they will. It can be very simply prevented. If you've decided early on the forum where the case should be heard, and if you've inserted the clause that the law to be applied should be something else, then you're in a much better position. You can actually state in the contract that it's the Chinese courts that will decide this, and it should be under Chinese law, and that way you can also enforce the judgment in China. And this can save you a lot of time, expense, and inconvenience. You don't have to hire lawyers in Zimbabwe. You don't have to fly your witnesses there. You don't have to go into the whole mess halfway around the world. Very simple, but people ignore it. Now, let's move on to mistake number two. Mistake number two is a classic. It's ignorance of international law. It's not bliss, nor is it an excuse, and it will come back to bite you. Let's say we're dealing with managers involved in, say, trade, and they don't understand which international law treaties, customs, and general laws apply. Well, what's happening is that they are at a competitive disadvantage, and sometimes they make mistakes that can cost them millions. For example, if the Vienna Sale of Goods Convention applies between an exporter and an importer, even if the importer has not been given title to the goods, as long as they are in his constructive possession, all risks of damage have been transferred to him, the importer. The importer must assure the goods are not going to be damaged and remain secure, as well as being insured and transported. They can't rest on their laurels, and they can't rely on the exporter for these sorts of things. And if they don't know it, they can be in serious trouble. So it's better to know the terms and conditions of how international laws and customs apply, so you can better structure the deal, you can protect yourself, you can maximize your rights, and avoid losing money or being liable to other parties. Now, mistake number three, very, very common, very, very common, making undocumented handshake deals. Always put your business dealings in writing. Don't naively assume that everything will go according to plan. This is often not the case, and when things go wrong, the two entrepreneurs may have very different ideas about what's supposed to happen. No matter how much you like and trust your business partner, you need a legally binding agreement. Not just detailing operations and responsibilities, but also what happens if you have opposite views. In many agreements, parties are actually at cross purposes on some issues, and I've seen this myself drafting contracts. They walk away with completely different ideas, but no one has said anything about it, so they don't really know that there is a difference. So the documentation and drafting process helps bring potential issues of contention to light, and you can have mutual agreement on how to sort them out later. Okay, now mistake number 4. Assuming that all forms of international trade finance are the same. Well, they may be the same in that they help you get paid, but you may not always get paid unless you're very careful. For example, the 2 most common forms of payment under international law in trade are bills of exchange and letters of credit. I'm sure you've all heard of them. The exporter's ability to secure payment for the goods is affected by the nature of a letter of credit and its terms and clauses. But a bill of exchange is rarely influenced by the types of bills of exchange and the very limited conditions you see on them. So an exporter is more likely to get paid with a bill of exchange. A letter of credit may appear to be like a guarantee, but it isn't, and they're usually structured and drafted for very hefty fees, and very strict conditions are enforced, so the bank rarely ever has to actually pay. It just assists a creditworthy importer as a credit enhancement tool and secures payment performance to an extent. So if you're an exporter, it's best to ask for a bill of exchange to be paid more safely, unless it's a very creditworthy importer. That's probably quite surprising to many people. Let's move on to common mistake number 5. Ignoring that international law can minimize risks in a global environment. Let's face it, doing business in another country is inherently riskier. That should make sense to all of you. You have to do your homework in understanding the real risks and recognize that they can be quite different from those you're used to. If you've only been doing business in Paris, for example, for the last 20 years, you may be clueless about the risks associated with unstable governments, sudden shifts in regulation, erratic investment markets, and all that sort of issues. In many cases, these sorts of risks can be safely managed if you are proactive enough and if you know about them. There are many ways to do this in a contract, but one of the most common ways, and you may have heard of it, is a force majeure clause, which should be inserted in every document, in any transaction, because it prevents a party being found liable for damages for frustrating a contract when an extraordinary event or circumstance beyond the control of the parties occur. These events include war, strikes, riots, crimes and acts of God like hurricanes, flooding, earthquakes, or any very serious event stipulated that prevents one or both parties from fulfilling their obligations. In practice, most force majeure clauses do not entirely excuse a party's non-performance, but they do suspend it for the duration of the problematic events. This may be absolutely necessary for you to buy time so you can complete your end of the project and not find yourself liable earlier. Now let's move on to common mistake number 6. Ignoring international security laws after a company is listed. Happens all the time. You may be surprised, but it does. Many directors, CEOs, and CFOs mistakenly think that once they've tapped international securities markets, that their disclosure obligations post-prospectus are minimal and hardly existent. The facts are quite the contrary. The listed company will now have to issue and disclose quarterly accounts. Under continuous disclosure regimes, they will have to announce to the exchange first any serious and material developments that happen in the company. Further, they will be subject to laws on insider trading, and they may have exposure for making any misleading forecasts that cause damage to investors. And sometimes they can actually even be sued directly for it, bypassing the company. So this is very serious. Let's say a Singapore firm lists on the London Stock Exchange. Let's say it wins a major contract, doubling its backload of future construction projects. It can't announce it selectively to the press or covering securities analysts. It will have to post an announcement on the London Stock Exchange first. If they don't do that, they can face a very hefty penalty fee, and of course there is much reputational damage if the press is writing about how you breached the listing laws. Now let's move on to mistake number 7. Mistake number 7 is that some people assume that international law doesn't apply to finance or banking. Well, nothing could be further from the truth, and having spoken to a lot of investment bankers in my time, I hear some things you just wouldn't believe. Some investment bankers think that their bank is in a partnership when they do a syndicated loan with other lenders, and that they share all of the funds and profits to the syndicated loan equally. This could not be further from the truth. The bank's rights and obligations are very, very different, and it depends on the documentation. The legal form of the syndicated loan is actually very different to a partnership. It's not a partnership, so they don't legally equally share profits. Legally, the syndication is seen as separate loans from each syndicate bank grouped together for no more than administrative convenience. So if you haven't set out what fees and profit share you want, you may not get it. A syndicate arranger who believes that the rest of the syndicated banks are in a common joint venture effort and that they're not liable to them is also entirely wrong. An arranger has fiduciary duties to the rest of the syndicate lenders and must not make any misrepresentations or any negligent misstatements, or they will live to regret them later on when problems arise. The legal nature of the relationship is far from the appearance, so you need to know about international business law to be able to handle the issues. Now, let's go to common mistake number 8. That international laws and the way they operate will always allow you to minimize tax. Well, they can help you minimize tax, but it's not always going to happen unless you know what you're doing. Let's look at cross-border financial leases. Because the tax treatment of a financial lease is very different from the tax treatment of a loan, the after-tax cost of a financial lease may be cheaper than the cost of a loan. That means it can be offered at a more competitive interest rate, benefiting both the borrower and the lender. However, these benefits depend on the way the deal is structured and the way the conditions to the deal are documented. The lessor usually, yes, does get a tax depreciation deduction, while the lessee gets an interest deduction on rental payments under the lease. But let's see how this can go wrong. Let's say the lessor is a German company leasing equipment to a lessee in Dubai. The deal is probably for 5 years, as most of these deals usually are, and after that the lessee can buy the equipment. But the legal issues here are actually very significant. If the German bank inserts a contract clause that the equipment has a very large residual value at the end of the 5-year lease, and it stipulates clearly in the contract that if paid the residual value, the equipment is transferred to the ownership of the Dubai company, then there could be problems. Courts and tax authorities may deny them the benefit of depreciation deductions and interest deductions. Why? Well, because of the option to sell the leased equipment at the end of the lease for residual value is clearly documented and not just implied for tax purposes, the contract could well be deemed a hire purchase financing contract and not an operating lease. That clause defeats the purpose of a cross-border lease. You could fix it very simply, but if you don't, well, tax won't be minimized and the deal won't work unless you understand international business law. Moving on now to the second last common mistake. Number 9. International laws are assumed to allow you to exclusively carve up markets and territories. Well, to an extent they do, but you need to know how to do it properly. Let's have a look at franchises. I mean, there are common problems there. Essentially, a franchise is a package of intellectual property rights, and that's what constitutes the essence of the franchise. But there is a fine balance between preventing know-how from being transferred to competitors, and restricting competition itself. And you need to be aware of that. For example, a franchisor of an exclusive restaurant in Hong Kong grants a franchisee in France the exclusive right to use the trade name, recipes, formulas, additives, ingredients, know-how, and systems. If under the terms of the franchise agreement, the French franchisee cannot open more than one restaurant and the prices that he has to charge are entirely fixed by the Hong Kong franchisor, then there are serious problems. Courts take into account the power imbalance between a franchisor and the more dependent franchisee. So this contract would have problems and it would probably be deemed void. A franchisor can recommend retail prices, but it should not be absolutely determinative on the issue. The franchisor can include restraints of trade clauses, like you can't open a restaurant within the same postcode as another franchisee, but a restriction that you can't open more than one could be deemed void and will probably be deemed void. The franchisor's mistake in inserting these contractual provisions will cost him all of the upfront money for the franchise and all of the royalties that he expected to be paid because the contract is void. It is wise to consult with the regulatory authorities in the jurisdiction of the franchisee before sealing a franchise agreement to understand where boundaries can't be pushed because you can subvert your commercial strategy and any advantages you expected. And now moving on to the final very common mistake about international business law. Many people think that international law disputes must always be resolved with international and very expensive litigation. Nothing could be further from the truth, and there are very good ways to be able to bypass that. Any party to an international contract, whether it's trade, commercial, banking, securities, or finance, need to consider early how to deal with disputes. Yes, litigation can be expensive and drawn out, so they should assure that in any contract they execute, alternative dispute resolution methods are included from the initial stages of the formation of the contract. The contract should set out the procedures for dispute resolution in a timely manner. They should start with bilateral negotiations for a strict time period, like 45, 60 days, no longer than that. Then they should agree to going to non-binding mediation with an agreed third-party expert. And finally, they should outline that a binding arbitration decision under which country's laws and which jurisdiction will be used, and that that's a fundamental term of the contract, so it can't be bypassed. That way, you've avoided litigation. These resolution mechanisms are far less expensive, they're much faster, and importantly, they can also salvage any business relationship as opposed to very adversarial litigation. An alternative dispute resolution clause is a wise investment in time, money, and reputational damage, and it can better serve the commercial strategy of your particular parties involved. And with that, I conclude this brief webinar, and I should say, because you're probably watching this over the net, that in the 3-day seminar we put on, that we will also cover internet law and e-commerce law, which is also fascinating. I hope to see as many of you as possible in the International Business Law for Finance Professional Seminar, which should be in a city near you. If it's not, contact Ethan Hathaway, and perhaps we can arrange it in a closer city, or we can do it in-house. Thank you for your attention. I hope I've taught you a few things that save you a great deal of money and save you a great deal of angst in the future. I bid you goodbye for now, and I look forward to seeing you again. Thank you very much.